Good morning, everyone, and welcome to Copyright Law for Creatives. I'm Eric Dillner, as one of your hosts today for the workshop, and also the CEO of the Shoreline Arts Alliance. The Shoreline Arts Alliance is the arts council that serves the shoreline of Connecticut and up the river through Middlesex County, as well as many other areas for statewide programming. Look us up at www.shorelinearts.org for many other opportunities like today's great offering, sponsored by the Connecticut Office of the Arts. We're thrilled today to have three amazing folks who are going to talk to us about copyright law for creatives. And we're absolutely honored to be hosting today's event. Tamara Dimitri from Connecticut Office of the Arts is here to welcome us with a few fantastic words to get us started. Tamara?
Hey, good morning, all. So we're very excited to be kicking off the series of 6 workshops that are going to be focusing on legal topics for creatives. And today's workshop is focused on copyright, and we have 3 experts in the field that will provide an overview, and we'll open up for Q&A along the way or at the end. They will give a bit of an overview. We are recording today's workshop, and we will make the recording available on our website for at least a period of time. So if you're unable to catch the full workshop today, or if you know of others who really need to see this content and information, we will make it available. The Volunteer Lawyers for the Arts is now here in Connecticut. We have a wonderful partnership with the Arts and Business Council of Greater Boston, who serves as the VLA for the state of Massachusetts, and now they serve as the VLA for Connecticut. And as part of our agreement with, this partnership is that we will also be offering legal workshops on an ongoing basis, and we'll cater to various topics along the way. So we do have a great series with at least a monthly workshop that will occur through April. So feel free to reach out to me by email if you need more information about the future workshops. I'll drop my email in the chat and or part of the Q&A, so you'll have that. But otherwise, I'm going to turn it on over to our presenters. Thank you.
Awesome. Thank you, Tamara. So thank you all for attending this morning, and thank you, Eric and Tamara, for hosting us. Like Tamara said, this workshop we have the series, of 6 workshops covering a variety of legal and business topics for creatives over the next 6 months. And we have the subjects kind of fairly locked in, even though we have a little bit of wiggle room. But this is also kind of for us to test what your cravings are for legal subject matter and topics and workshops, so that Tamara and Yen and I can plan for future workshops. So at any time, if you have feedback or topics that you're interested in learning more about, be it something that won't be discussed during the series or a deep dive into a topic that we're covering really briefly, please let either Tamara, Yen, or myself know. So without further ado, we'll get into the subject matter. I'm Luke Blackadar. I'm the Deputy Director of the Arts and Business Council of Greater Boston. We run the Volunteer Lawyers for the Arts of Massachusetts and now in Connecticut, as Tamara said. And we do a bunch of different programs for artists. And I'm joined by my art law fellow, Yen Nguyen, who is also a Massachusetts attorney and a Connecticut attorney, one of my former legal interns, now staff, and fashion designer, visual artist, small business owner. And also I'm joined by Professor Bruce Jacoby, who's become a friend of mine over the past couple years, clinical faculty and director of the Intellectual Property Clinic at my alma mater, Northeastern University School of Law, graduate of UConn School of Law, and also a working artist, writer, filmmaker. I know how awkward it is to sit and watch someone else introduce you. So if Yen and Bruce, you want to also add anything that I missed, please feel free to do so.
Just to correct you, it's Jacoby, not Jacoby, but that's quite all right, Luke.
I've never heard you speak your last name. Now I know, now I've learned that. Okay, thank you.
Thanks,
Awesome.
Luke. That was a great introduction. As always.
Okay, so let's get into the topic at hand. So we're going to talk about really copyright basics and the lay of the land and really general legal framework. There's a lot of stuff here. Please feel free to drop your questions in either the chat function, or we have Q&A enabled as well, and we will check them periodically. But we're going to try and give you really like the 30,000 foot view of this, and we'll get into a couple topics a little bit more specifically. I already see that we have a question, what do we know about copyleft and is it actually viable? That is a pretty nuanced topic. We might have time to get into it, but it deals with licensing. We might get to it. So first, I always like to put copyright into context. When we talk about property from a legal perspective, we're really talking about three varieties. Real property, so land, a parcel of land, permanent fixtures upon it, your house, your building, your apartment. Personal property, physical, tangible property that is not permanently affixed to land, things like your clothing, your car, your phone, any kind of tangible personal physical asset that is not permanently affixed to a plot of land. And then this third category of intellectual property, which is kind of a misleading name because it really includes 4 distinct and discrete types of property assets, but we group them all together under this one title of intellectual property, mostly because they really reflect intangible property rights. So there are 4 types of, the big types of intellectual property assets that we focus our time on. And we're really, again, for this presentation, only going to focus on copyright. But the 4 big ones are copyright, which ultimately protects your original creative expression and gives you the power to stop other people from copying it without your permission. Trademarks, which protects, it identifies the source of a product or service. It's really not so much brand protection as consumer protection. I can go into the shoe store, and when I see that swoosh, I know what that means. I know that means Nike, and I know what that means in terms of value, quality of materials, reputation of the brand. So it identifies the source of a product or service so that we can make educated purchasing decisions based on our experiences. Patents protects novel, useful inventions against copying, manufacturing, and selling without permission of the inventor or the patent holder. And then last, trade secrets, which really protects any type of information that gives you some type of economic advantage and that you take an affirmative step to keep a secret. Most commonly, you see this in things like, recipes. You might see it in things like formula for cosmetics. You might also see it in business forms like vendor lists, client lists, certain business methods, that kind of thing. So those are really the big 4 types of intellectual property assets. And maybe some or all of you have all 4 reflected in your arts practice. But for purposes of this morning, we're just going to talk about copyright. So I always like to ask, why do we care? Why do we care about copyright? Why do we spend all our time thinking about it? Why do attorneys like me and Bruce and Yen harp on this so much and say you really need to know this? So one, you might, especially if you are a artist who works in traditional visual media and you're selling products, you understand that your art has value, the commercial value in selling that physical piece, that painting, a print of that photograph, selling that film or that album, but also the power that you have to make and distribute copies of that creative expression is also extremely powerful and extremely valuable. It gives you the ability to control who has access to your work, who has access to your creative expression, who can enjoy it. And that is a very, very powerful tool to have. And really, it's kind of the fundamental, the crux of your artistry, the power to control who gets to enjoy your creative expression. So that's why it's important. And, it is a right that you have and that you should be aware of. It's easy to get and a little bit counterintuitive to protect. So it's really helpful to kind of understand what it is you have, and it's part of your art portfolio. So I'll pause and ask Bruce if you have any Any color commentary so far? You're muted. You're muted, Bruce.
You should consider yourself fortunate. I would add that it's not just a matter of controlling the access to who has rights to it, but it's also controlling the commercialization aspect of it. You would not want, I would imagine, you being the audience, and welcome all, to create a piece of music or a theatrical play or a film and have it viewed widely without attribution to you as the author, and B, without compensation for your work. Now, the question that was in the chat room from Patricia about copyleft opens up a whole subsidiary set of issues, which, as Luke said, we might have time to discuss later on. But that does play into the commercialization aspect of it, the time frame of how long a copyright right exists, and things of that nature.
Awesome, thank you. So first we'll dive into what is copyright? What is this thing called copyright? So copyright, again, it's a form of intellectual property, and it protects original works of authorship fixed in any tangible medium of expression. And this comes straight out of the United States Constitution. So this is, from our, the ultimate primary source of law. The idea is basically, we want to reward creatives. We want to create incentives for creatives, for inventors to, express themselves, to create things that, advance humanity, push us forward scientifically, technologically, and culturally. So we create in the Constitution this right for artists to control access, attribution, exploitation, commercialization of their art and their creativity. So this is the legal subject matter. This is what copyright protects. So there are three pieces to it: originality, this phrase works of authorship, and then this notion of fixation. And we'll talk about what those mean. Originality is fairly straightforward. It really just means that your work was independently created, that you exercised your own individual creative judgment to create, to bring about this work. And ultimately, you didn't copy it. So here you have the two legal criteria. It's independently created by an author, and it possesses at least some minimal degree or a modicum of creativity. None of us go through our arts practice hoping that, boy, I really hope that my work has a bare modicum, a minimum of creativity. But for legal purposes, what this means is it doesn't have to be never before seen. It doesn't have to be completely novel. You might hear that word novel in patent, where you do have to have a truly new invention. But in the copyright world, you don't. It doesn't have to be never before seen. It really just means you created it independently, exercising your own independent judgment, and that you didn't simply copy someone else's work or some pre-existing expression, which some of you, your ears might already be ringing thinking, well, I'm a collage artist, or I make derivatives. We'll talk about what that means. So originality simply means I created it independently. What is a work of authorship? It's these 8 things on the left, and this is a very dense slide. We're not going to go through every single thing, but we have defined by law what a work of authorship is. And it's these 8 categories, but all of them within them are very broad. Like, they seem fairly finite, but within them, these are all very expansive categories. So literary works, so that includes kind of what you think of traditional literature, poetry, novels, manuscripts, screenplays, things like that. But also it includes computer software, source code, and object code. So it includes both of those components too, for those of you who are programmers or software developers. Musical works, including the lyrics, dramatic works, plays, theater, including the music, pantomimes, choreography, pictorial, graphical, and sculptural, so the world of visual arts, motion pictures, sound recordings, things like that, architectural works. So all of these are fairly broad categories. And then on this column on the right, you have things that aren't included. And I think an easy way to think about it is a lot of these categories of works that aren't protected by copyright are often going to be protected by some other type of intellectual property right. So ideas, methods, concepts might be protectable by a patent. Titles, short phrases, not protectable by copyright, but possibly by a trademark if you're using it to sell a product. Recipes, formulas, that it could in theory be a patent. It could also be a trade secret. Scène affaire, which I see someone mention in the comment, is this notion of things that are essential to a genre or customary to a genre, that you really, I think another way to think about it is kind of a cliche. Like, it's been expressed so many times and it's so traditional to telling the story that it wouldn't be fair for someone else to try and claim a monopoly over, you know, I'm writing a drama about like a boys coming of age high school tale and there's like a fight in a locker room or something like that. It's like, no, every YA novelist has written that story or written that scene. Like, we can't control and stop other people from writing a similar scene. Fashion designs, furniture designs, architectural works as depicted by photographs, those are functional. Functional articles are only protectable by patent. So to the extent that, you know, clothing, furniture has a functional purpose, again, public policy is that we don't want to stop, you know, we don't want IKEA to have a monopoly on manufacturing chairs. We need chairs. We need them in order to, you know, recline and relax, or, you know, we need dressers and tables and stuff like that. So because those are functional, we don't want someone to be able to control, you know, access to creating these assets. Things like this are typically not protected by copyright, usually the purview of patent. Bruce, do you have anything to add?
I'd add, Luke, the dichotomy between ideas and the expression of ideas. Creativity protects the expression of an idea, but not the idea itself. The example that I give to my students usually is to explain, it's one thing to, Margaret Mitchell, the author in the 1930s, anyone can write a novel or do a film based on a novel about a Civil War era plantation in Georgia, and the story of involving slavery and social constructs. That's not copyrightable. That's just the idea. The expression of the idea, as expressed in the novel Gone with the Wind with Rhett Butler and the plantation called Tara and Scarlett O'Hara, that is protectable. It's the expression of the idea, and that cannot be copied or reproduced, or a film version made of it, which is a derivative work, without permission from the author or the author's estate, as long as it's still protected by copyright.
Yeah, the idea is we don't want people to try and claim monopoly of an abstract idea that's rattling around in your head if you've never expressed it in some type of reproducible, perceivable form. And this kind of relates to another question that we have from Patricia about, you know, whether can you protect by copyright a technique, you know, in every sense of the word, like an artistic discipline or a method of creation. And no, you can't. You can't, depending on your method or your technique, you might be able to protect it via a patent if it's patentable subject matter. And that is, you know, that is a whole other discipline that requires more technical expertise. But even things like, you know, creative disciplines, like, you know, schools of art, like, and kind of genres and styles of art. No, you can't protect that style in the abstract. You know, I think, for example, you know, a goofy example, when I was a little kid, I had no concept of, like, you know, what anime was. So I thought like every single anime I saw was done by like the same studio. And I was like, oh, wow, they do a whole lot of work. And then, you know, when I was older, I was like, oh, this is a specific type of creative discipline. This is a very specific genre of animation. So you can protect your particular expression using that method or using that discipline or using that technique, but you can't protect by copyright the actual technique itself, which gets to be a real problem for certain types of artists and certain types of creative disciplines where, you know, a lot of their creativity lies in their particular style. But as Bruce says, copyright protects the expression of idea, not the idea itself.
One more interruption, Luke, if I may.
Yeah, no, go for it.
Lisa just asked about collaborations. This reflects on something you said earlier about how the requirement that a piece of work be independently created. That does not mean it has to be created by a single person. Partners can absolutely collaborate. Co-authorship is recognized in the statute. My older daughter is unfortunately copied what I did and listened to what I did and not what I said. I was a playwright. My daughter is a musical theater writer. She and her partner, her writing partner, who does the music, my daughter does the words, they own the copyrights together. They have joint ownership of the registered copyrights, which is another topic for discussion about what rights each partner of a work does. Your second question, Lisa, about Visual Artists' Rights Act is a very, very tiny subset of the Copyright Act, Section 106A. It protects limited works of art, no more than 200. We're not going to get into that today. It's sort of a independent piece of the Copyright Act that doesn't come up a lot in general practice.
Thank you. Yeah, I had slides on the Visual Artists' Rights Act, but it really is, it's a kind of a niche subset of copyright. And it's, you know, the history is like, the US was kind of very reluctant to adopt what's called moral rights, this idea that your physical work of art, the integrity of your art is also intimately connected with yourself and your reputation as an artist. If we have time, we can talk about it really briefly, but it is like, it's its own thing. So just to give an illustration of Santa Fe, because I think it's kind of a tricky concept somewhat, is basically like, you know, this is a still from a scene from Thunderball. So classic James Bond film, classic original OG James Bond, Sean Connery. And, you know, you think of a story about, you know, 60s era, 50s era kind of espionage, you know, post-Cold War, Cold War era espionage. And you might think of like, you know, human intelligence, kind of like James Bond. And, you know, oh, I'm this suave European spy. I'm going to, you know, a club and I'm playing a high stakes casino game. And, oh, I've encountered the antagonist of my story. And, you know, it's a terse, tense encounter with my arch adversary here. Like, this specific expression told in this story, in this film, you know, written by Ian Fleming and, you know, directed by Cubby Broccoli, like, no, you can't copy this specific expression. You can't copy, you know, the similar scene that Ian Fleming told in Casino Royale or in the subsequent films. But that doesn't mean you can't tell a story about a spy going to, you know, a high stakes casino game and having this encounter, you know, by a chance encounter with the antagonist. It just means you can't tell this specific expression. And maybe if you're telling this kind of story, this kind of, again, Cold War era espionage, this is just kind of part of how, particularly like the British Royal Navy, this is how they gathered intelligence at the time. So that's kind of the idea with something like Sen Affair. It is a kind of a tricky concept. Do you have anything to add on that, Bruce?
I don't, but Luke, do you want to address the questions as they come up, or should we hold off on some things that I'm seeing pop up in the Q&A section?
I think if it is relevant, like I think some of these, like copyleft, I think we can get to a little bit when we talk about kind of the bundle of rights. And I think photographers we can get to about registration. I have a slide on Warhol and Goldsmith. Don't worry about that. And I just see Sarah's question here. So yeah, I think we can address them as they come up, if they're kind of relevant to the topic. So let's see. if an idea or way something is created can't be protected by copyright, does that mean I can use another person's idea in my art? For example, can I drape fabric through or around something like Christo? Again, it really is, are you copying the expression? The thing is, the end product that you are creating, is it too similar to someone else's, or are you copying someone else's expression of an idea? If the methodology results in, if you use the same method, but you come up in two very different works, then no, that's fine. If you're copying someone's methodology and it results in creating a near identical or extremely similar expression such that, you're really copying someone else's creative expression here, you're saying the same thing, that's when it becomes a problem. But this is, again, you've touched on, you and I think Patricia have both touched on kind of a tricky question of, we all struggle with, like, one, the distinction between discipline, like artistic discipline and creative methods, and the final product. And also, where is the difference between I'm creating a derivative of someone else's work, and we'll talk about what it means to be derivative, versus when have I created my own, I've used some source material, but I've created something totally different and unique and unique to me, and totally a brand new expression. So that's kind of, we'll get to that a little bit more. But first, let's just wrap up these three elements of what is a copyright, what does it protect. So we talked about originality, you didn't copy it. We talked about works of authorship, those 8 categories. And now let's talk about fixation, which is what Bruce was getting to earlier about copyright protects the idea, the expression, not the idea in the abstract. You have, in order to get copyright protection, your idea has to be expressed in some type of tangible, replicable, reproducible form. It has to be perceivable. We have to be able, another person has to be able to see it and experience it. If your idea, again, is rattling around in your head in the abstract, then it doesn't have protection. For a lot of artistic disciplines, this is fairly intuitive. If you're a painter or a visual artist, once you commit your art to some type of form, either paint on canvas or a digital image or a photograph, or if you're a literary artist and you've typed up or written down your manuscript or your poem, that's fairly intuitive. Where this gets difficult is performing arts, really, where you might have live expression of some creativity that's not necessarily captured in a permanent form. So a live musical performance, a live theatrical performance, a live, dance routine, or, that kind of thing. If a tree falls over in the woods and no one's around to photograph it, or no one's around to record it, is it protectable by copyright? No, it's not. So this is, to use kind of your example, Bruce, with you and your daughter as playwrights and musical theater producers, like, if you're seeing your stage play carried out on stage and no one's recording it, is it protectable by copyright? Do you have the ability to stop them from, recreating that stage performance?
Well, the answer is that, of course I do, because the written word is copyrighted, and for them to perform it, even if their performance is not fixed in a tangible medium, meaning it's not being videotaped or filmed or recorded, they would still be technically infringing the written portion of the work. As soon as I, behind my keyboard, hit Command Save, it is fixed in a tangible medium. It is on my computer hard drive. It is not just eligible for copyright, it is copyrighted from that moment on. I don't have to register it. I don't have to do anything. The work is fixed in a tangible medium. It has the requisite level of creativity and originality. It is copyrighted. It is protected. Someone else cannot take that script, even if they had some access to it, and perform it and put it on stage without my express permission.
Yeah, and that's because we have a expression in a tangible form. Maybe it's not the stage play, but we have the actual written play, the written play, the written music, the song, the composition, those things.
And similarly, Luke, the same holds true for choreography.
Yeah.
If a choreographer uses dance notation, which is a written form to explain to dancers and choreographers what and directors what the steps are, what the dance performance should include, then the performance of the dance piece without permission would be deemed infringement.
Yes. So Patricia asks, so without dance notation, there is no copyright? Not necessarily. That's one way of recording. You could also record it, as you see here. You could film yourself doing a rehearsal of the dance, or just, you know, record yourself doing a performance of that dance. Little bit trickier where, you know, does my video recording of myself performing the dance, does it protect the dance itself, or does it protect just that particular video? That's a trickier question. You know, belt and suspenders approaches have the dance notation, you know, if you can have both, but that gets a little bit trickier. But no, not necessarily. So the idea really here is your work needs to be fixed somehow. If it is just an idea that you've never put down, that you've never expressed it or reduced some type of tangible form, then you do not have copyright protection. So those are the three fundamental foundations of what is copyright protectable subject matter: original, works of authorship, fixed. So what is copyright? What do I get from copyright? Why do I care? Again, this is what you get. When you own a copyright, you get 6 exclusive rights. Exclusive meaning you as the author or owner, the author of the work or the owner of the copyright. Those don't necessarily have to be the same person, and we'll talk about what that means. You have these 6 rights. You have the exclusive right to make reproductions, to make copies. You have the exclusive right to make derivative works based on the original. So, you know, I've written my stage play, and now I've adapted it into a actual performance of that play. I've taken that performance and I've adapted it into a film. I've taken that film and I've done a spin-off series. You know, maybe I've done a television series based on it. I can make derivative works within and without the same medium. I have the power to distribute reproductions. So I can sell copies of my work. I have the power to publicly perform my work, be it my music, my play, my choreography. True capital P public in a public space, you know, Boston Common, you know, out in the public owned town square kind of thing. Public property. I have the right to publicly display my work. If it's literary, if it's, you know, audio visual, if it's visual. I guess if it's audio visual, it's technically public performance. And I have the right to publicly perform sound recordings. Sound recordings are kind of relatively newer recognized copyright. The recorded performance of a song. So, you know, think of your like MP3s, that kind of thing. I have the power to publicly perform that sound recording via digital audio transmission. These are the core of copyright. These are the rights that I have. And I have the ability to exploit them however I want. And they belong to, you know, the copyright owners exclusively, to the exclusion of everyone else in the world. Bruce, you want to add anything about kind of
the rights? Sure. The rights that Luke just described are individual rights. They can be treated individually. They're divisible, in other words. I, as a copyright owner, can license someone else to do to make reproductions. Party A, I can license Party B to create a derivative work, a film version of a novel, a stage version of a short story, whatever the case may be. You have complete control, and you don't have to deal with just one licensee. You can deal with many. And if it's a non-exclusive license, you can grant derivative works licenses to permissions to different other creatives who want to base their works on you. There's also a crossover here. I think it's important to note between copyright and trademark law. Sarah asked whether copyrights expire. The answer is yes. The Constitution uses the term limited terms only is the exclusive rights are granted. But under today's law, limited terms mean that a copyright exists for the life of the author plus 70 years in most instances. It could even be longer than that. Many of us in the law and outside think that's an obscene amount of time. The copyleft concept comes into here. That's an invented term by a man named Lawrence Lessig, who also believes that life plus 70 is too long a term. So he advocates for open source licensing, Creative Commons, where things are given and shared so the public can benefit. We as a society can benefit from them in a larger way. The derivative works concept is very important, though. It arguably the most important element of the six rights here. I think of it as the most important one.
Yeah, and it's like I said, it's a tricky right. It's a tricky right because we still, and you know, as Lisa mentions in the comments, you know, asking us what do we think about Goldsmith versus, you know, Warhol v. Goldsmith. No one knows yet. We don't know what the outcome is going to be, but we know it's one way or another. It is going to be very consequential on kind of giving us, ideally, some frame of reference as to where is the line between Bruce's right to create a derivative work, his exclusive right to derive his source material, and my right to, or my ability to create my own original piece based on his source material, to the extent that it's.
And this brings in sampling in the music industry,
Yeah.
Which I'm sure you're going to be talking about in this presentation. It brings in a whole concept in copyright law called fair use, which is what the Andy Warhol Prince case is about. It's shifting rapidly. The Supreme Court came down with a major case about fair use just last term. So things are changing at a fairly rapid pace, given the internet and the access to materials worldwide. Yeah.
So let's talk really quickly about ownership, and we will circle back to this concept of licensing, and we can talk about copyleft in a little bit more depth as well. So ownership in general, default rule is the author of the work, the person who fixes the work in a tangible medium, is the copyright owner. If you have multiple authors, you have two people who've jointly created a work together, then they both share ownership. They are both co-owners of the copyright, meaning they both have the exclusive rights to exploit the copyright in that work that they've created together. And then there's this exception to the rule. There's this quirky exception called works made for hire, which basically says under certain limited circumstances, it's entirely possible for the person who was the creative force behind the work not to be the owner of the work. And there are two common flavors of a work made for hire. In both of these circumstances, the person who is the employer or who has basically commissioned the creation of the work is the owner of the copyright. So one, I think most commonly we have works created by an employee within the scope of their employment. So I can tell you, I created this PowerPoint for my work with the Arts and Business Council, but you'll note on the bottom of every page, copyright Arts and Business Council Creative Boston. I put the words here, I synthesize the goofy images and the memes, but ultimately this belongs to my employer because I created this within the scope of my employment as deputy director and the person who runs this program. I don't own the copyright here. Arts and Business Council does.
And technically speaking, Luke, this is one of the weird things to get your head around, is that Luke is not only not considered the owner of this material, he's not even considered legally the author of the material. Nope. And that is a very, very vital concept about the distinction between ownership and authorship, because authors do have rights down the road, which Luke would never be able to avail himself of because he is not technically, legally, even the author of the work that he put together.
Yes. So I was physically the person who put this, who created this, but I am neither the owner of the copyright, nor as Bruce said, nor am I legally the author. I am not, my employer is deemed the author of this work. So, if you're an animator, you work for Pixar, your animations are going to be owned and authored by Disney Pixar. Then this other category is specially ordered or commissioned works. And the first thing I want to say is this is a very technical term. It does not mean what we think of when we think of a commissioned piece. You're hired by, the Connecticut State Office of the Arts to they've hired you to put on a public art installation. That's not what we're talking about. Or you've been commissioned by a client to create, to draw a portrait or to shoot a wedding or something like that. We are talking about a very narrow group. There's only like 9 types of works that fall under special ordered or commissioned works. And in order to have a work made for hire under this type of relationship, it has to be one of 9 very specific types of work, and you have to have a written contract signed by the creator saying, this is a work made for hire, therefore my client actually is the author of the copyright. So ones that are usually relevant to most of my clients are contributions to collective works, contributions to an audio-visual work like a film, screenwriter, musical score, that kind of thing, translations of a work, compilations. You also have supplementary works, instructional texts, answer materials for tests, atlases for you cartographers out there. Those are considered works. If you are hired to create those works and you have a contract with your client that says, this is a work made for hire, then your client is the author and the copyright owner in that work. You definitely see them in certain industries. You see, collective works, compilations, certainly film. Why do these big film production companies own the rights in all of these, television shows and films? It's because of this regime here. But, for most artists, I've been hired for, $5,000 to paint a portrait. That's not what we're thinking about. For most part, you are still the author of that work and you still own the copyright. It's just, you've been hired to create a piece, to create a custom piece. So let
me just join one interruption here, Luke. It's not to say that the copyright owner cannot and may not be asked to assign all rights.
Sure.
In other words, transfer ownership. So if the question about painting a portrait came up, it may well be that the person who commissioned the work of art to have his or her spouse's portrait painted may say to the painter, by the way, in exchange for the $5,000, I would like you to sign a document that transfers ownership, assigns all ownership to me. It's possible that happens. It happens in our law school clinic all time in many different guises. One notable absence from the list of 9 types of work that are subject to the work made for hire doctrine, the creation of source code, computer code that's written by a human, is not one of those 9 things. So under no circumstances would an independent contractor who writes source code for hire be deemed technically a work made for hire. It doesn't mean the person who's paying the source code writer cannot acquire ownership, but it wouldn't be under the work made for hire doctrine.
Yeah, and there are, as Bruce says, there are other ways to acquire copyright ownership through contract and through property transfer. And we'll get to that. So Patricia has a really great question that comes up all the time. Wait a second, if a scientist does research and writes a few papers based on it while working for a university, is she's still listed in the journal as author, but the uni owes the copyright? So this is, in higher ed, this is a very common exception, kind of a cultural exception to the work made for hire rule. So in a lot of institutions of higher education, when you're dealing with students and particularly faculty, usually in the student handbook and the faculty handbook, the university will usually be pretty explicit in saying, we do not claim copyright ownership of students' creations. So this is something that I deal with, and I'm sure Bruce deals with students like, oh, I created this wonderful stage play for my final paper, my final capstone project in art school, does that mean the university owns it? No, usually the university will say in its student handbook, students retain ownership. They reserve all the rights in the work they create for us. You give us a license to do this, that, the other with it, maybe. And similarly with universities and usually faculty members, usually to entice very high caliber scientists and researchers, universities are going to say, you know, we're going to give you the resources. We expect you to publish and publish through our publications. You still own the rights in the work you've produced, but you know, it's going to be in our journal. It's going to be through our press, and it's, you know, you're going to be acknowledged as faculty at our university, that kind of thing.
This has become a huge issue since COVID struck, and a lot of higher education and not higher education went remote, went on Zoom. Nationwide, faculty members were concerned that a university, their employers, could record the classroom sessions of their giving a presentation and use them with other groups without their permission. And what is that going to do with the hiring process and the retention process for faculty members? Most universities have taken steps to address this. As Luke said, they will say, we do not claim ownership of your written materials, your presentation to a class, but we are allowed to use it under limited circumstances with your permission. And by the way, this concept of a university relinquishing its claim to copyright ownership is a contractual one. It's not necessarily a legal one. It's saying to the professors, we agree in exchange for hiring you that you own your copyrights to your work. It does not usually go towards patents. If an engineering school or a tier 1 research university creates a drug, creates a mechanical device that is going to make a lot of money, the university is almost certainly going to retain ownership of the patent in that work, sharing proceeds perhaps with the professors and staff and even students who contributed to the invention.
Yeah, and it's a lot more complicated in the kind of patent world, because that's when you start having a lot of sponsored research, and that's when you have, you know, Office of University Counsel that's negotiating 6, 7, 8-figure contracts. You know, we want you to research and develop this, you know, pharmaceutical drug for us for our use in the future. So yeah, once you start to get to those high figures going around as well, that is the tricky part. So ownership, if it's not already clear, ownership is pretty complicated, especially when you're dealing with works that embody a number of constituent, distinct copyright protectable pieces coming together. As we already talked about in film, contributions to a film or audiovisual work are one of those categories of works made for hire. So if you go and you're brought on as a musical scorer for, you know, Paramount Pictures, and you're scoring a film, they're going to have a contract with you that says, okay, you, as the musician, the composer, you are creating this copyright, you're creating this music for us, and we are deemed the author. We are deemed the owner. We've authored this work for this film. You know, you also have that in, again, stage performance. You have it in video games, where you have a bunch of different components coming together to create one work. And you know, one thing to keep in mind is that, remember, the default rule is that copyright belongs to the person who fixes the work. The author is the person who fixes the work in a tangible medium of expression. The example that I think of most commonly is when you have something like film or music, where you're in the recording studio and you're singing your heart out, but you have the audio engineer on the other side of the booth. They're the one who's hitting the big red button that says record, and they're the one who is physically recording and fixing your performance in a tangible medium of expression. You know, default rule is that person the owner of the song? Are you co-authors? So that's an area where it gets a little bit tricky, because the people who are, again, kind of like works made for hire, but not the same, the creative forces who are actually doing the creativity are separate, can be separate from the people who are actually the ones physically capturing it in a tangible medium of expression. So sometimes this is dealt with by contract, sometimes we deal with it through work made for hire principle. Sometimes in some cases, we do have a bunch of co-owners of a work. We've all come together to create this one indivisible creative expression, and we're all authors of it. You know, the band getting together to perform a song, that kind of thing.
Agreed. And I would add that co-ownership and co-authorship means, as Luke said earlier, that again, I'll use my daughter and her partner as an example. Either one of them has the inviolable right to license the work, to do it without the other's permission even. So if my daughter Alana wants, had contact with a theater and they want to do the musical that they wrote together, she doesn't need Scotty, her writing partner's, permission to do it. Her only obligation legally is to make an accounting to Scotty, and that they share the proceeds in agreement to whatever they have, whether it's 50-50, which it is in my daughter's case, but the artists can decide among themselves. It's not going to extend generally to the person in the studio who hits record button. That person, even though, yes, they technically were the party responsible for fixing it in a tangible medium of expression, they're not generally going to be considered an author, because the recording contract is going to say that the recording studio is fulfilling a technical function only and makes no claim of ownership to any of the materials created.
Yes, and that, I'm glad you mentioned that point, because that is something like the contract, if you're dealing with if you're a documentary filmmaker, or you're a screenwriter and you have a film crew, or you are a musician and you're going into the recording studio, most of these service providers, any of them that are worth their salt, will have a contract that says, I'm providing this to you as a service. Yes, I'm the one who's physically hitting the record button, but as my contract, I'm assigning you the rights and the copyright, or, I'm not claiming any ownership in the copyright of the work that's being created here. Where it can get tricky is when you don't have a contract, and then it's like, oh, do I now have some type of, does this person have an ownership stake now that I didn't know about, I didn't keep track of?
And this came to the forefront in a couple of years ago. There is a very well-known and highly respected Broadway director, a fellow named Joe Mantello. He used to be an actor. He was in the original cast of Angels in America. He was the director on Broadway of Wicked, which is still running. He was the director on Broadway of Assassins, of Richard Greenberg's play Take Me Out. Many shows. He is one of the best Broadway directors, theatrical directors there is. Wicked was performed down in Florida, and the company that did Wicked under license, they got license from the creators, used a lot of Joe Mantello's stage directions, basically copying the type of style that Mantello used when he directed it on Broadway. Joe Mantello sued for copyright infringement, claiming that he had a creative ownership of the directorial elements of the production. The court in Florida went to the Copyright Office for some guidance on this, and the Copyright Office said absolutely not. The director, the lighting designer, the set builder, even the set designer, they do not have copyright ownership in the underlying material. It was a huge issue in theater, but it also extends to other artistic forms. Joe Mantello's ownership rights and monetary stream as a royalty comes from an agreement, a contract he has with the producers and the copyright owners. It does not come from the independent direction of the underlying work.
Yeah. Thank you. So, okay, we have a foundational understanding of ownership, and we've talked and hinted at kind of how you transfer ownership and move around ownership. And that kind of gets to what we started talking about a little bit earlier with licensing and copyright assignments. So first, fundamentally, the sale of a physical work that embodies a copyright is distinct from transfer and sale of the copyright itself. So, Bruce and I have the enviable, Bruce Yen and I all have the enviable task of being law professors. So, you know, I have my textbook that I teach out of. I've purchased this. I didn't purchase it. I got a professor copy. They just gave this to me for free because I said I'm a professor. But so I have this physical copy that embodies intellectual property, that embodies copyright protectable expression of the author's editorial notes and discussions and explanations of certain legal concepts and stuff like that. I own the physical copy. It doesn't mean I own the copyright. And if I transfer, if I sell this, if I give this away or throw it away or transfer it to someone else, that copyright still stays with the author, with the owner, with whoever has the copyright in this book. It doesn't move to me. It doesn't change despite me dealing with kind of the physical property. So I buy an album, I buy a vinyl, I resell it to a friend. I don't own the copyright, and the artist who created that music has not given it up in virtue of giving me the physical property. The only ways to transfer copyright are either by, you know, this work made for hire principle, where in virtue of your relationship or a contract, you automatically give the person who's hired you the copyright in the work you've created, or what is called a copyright assignment, which is it's a sale, it's a transfer of complete ownership of the copyright. And a copyright assignment can only be executed by a written contract signed by the previous copyright owner. This is one of those rare instances where you really need to have a contract in writing. Now, Bruce, I can't remember. Can I assign one element of my copyright, like one right? You know, I can assign Yen the right to make copies, and I can assign you the right to make derivatives, or is it wholesale? Can I only assign, you know, you get all or nothing?
The rights are divisible. They are individually assignable. And to answer someone's question from earlier on in this discussion, what happens if the author dies? Where do you go to either get a license or try to purchase the rights to it? Well, they are not only divisible, but they're divisible. So copyright rights go with an estate. Generally speaking, it can be in a will, or if not, it just goes to the legal inheritors. So just because the author dies does not mean the copyright rights disappear.
Yeah. So assignment, I am permanently giving copyright ownership to someone else. Alternatively, you hear many of you might have heard in your arts practices before, copyright licensing, meaning I am giving someone permission to use my rights. I'm giving someone permission to exploit one or multiple or all of those 6 exclusive rights that belong to me. I'm giving someone the ability to use those rights, but I still retain copyright ownership. So in, you know, an example that Bruce used earlier, you know, I have my stage play that I've written. I can grant someone else the right to perform it. I can grant someone else a license to make a sequel and, you know, another written work. I can also control licensing by time and by geography. If I'm a book author, I can say, hey, Penguin Random House, it really should have been Random Penguin House. What a missed opportunity. Penguin Random House, you can license this. You can publish and distribute my book in the continental United States, Canada, and Mexico. Meanwhile, Simon & Schuster, you can publish my work in the European Union and the UK. I have the power to make that decision, and I can say, you know, Simon & Schuster, I only want you to have the license for 2 years. Penguin Random House, I want you to have the license to distribute and sell my book for 3 years. So these licenses, as Bruce said, are divisible. These 6 rights, the right to make copies, derivatives, sell copies, public perform, public display, public performance of sound recordings. I have the ability to separately, independently grant people those rights and those permissions in any combination I want. And within that, you have a couple flavors of licenses. You have non-exclusive, meaning yeah, I've given Bruce the a license to publish my book, but I also have the power to publish it myself. Or you can have an exclusive license. I grant Yen an exclusive license to publish my book, meaning that permission is exclusive to everyone in the world, or exclusive to them at the expense of everyone in the world, except including myself. So if we have an exclusive license, that licensee is the only person, the only party that can exploit those rights. I usually caution people, if you see the words exclusive license or exclusive in a contract dealing with intellectual property, take a look at it closely and understand what that means. That means that you are necessarily going to be relinquishing your ability to exploit your copyright for at least some period of time.
It can, and keep in mind, as a licensee, as the person who's acquiring the license, if you are granted an exclusive license, or if you're seeking an exclusive license, you can expect to pay a lot more than you would if you were granted a non-exclusive license. If you're granted a non-exclusive license, you better be very, very careful that if I want to publish the book, Luke's book in the United States, I may not want him to retain the right to publish it himself, because then the book can be sold and I'm not going to make a penny out of it. So in certain industries, exclusive license are the norm. And the only other thing I would add to this part of the discussion is the distinction between licensing and assignment can be summed up very, very simply. A license, you maintain ownership. Assignment, you are relinquishing ownership of the copyright for at least 35 years. You know, that's a whole other topic we're not going to get into today.
Yeah, there is this principle of copyright termination where, in theory, depending on who currently has the copyright and what type of copyright ownership it is, if there's an outstanding license, it is possible for the heirs of a copyright owner or the original copyright owner to get those rights back. But it is among
even if there's an assignment.
Yes,
the author of the copyright can void a valid assignment. That transfer of ownership can be voided after a period of 35 years under many conditions.
Yeah. And this is also, this notion of licensing is also where copyleft comes into play. So the idea of a license is, I need permission in order to use someone's work. I need a license. I need their permission, either written or verbal or whatever, in order to use their work. The idea of copyleft is kind of twofold. One, it's this idea that, as Bruce said, copyright lasts a really long time. It does center a lot of power in the author of a work, but it also restricts work for a long time. So this idea of copyleft is, one, let's make work available for people to kind of freely license. And two, let's also kind of simplify the process of, I'm a rights holder, I have my work, I don't want to separately negotiate with 10,000 people. I don't want to separately negotiate a license with like 10, 30,000 people. I just want to say my work is out there for you to use, but I'm going to set certain standard terms and conditions on that license, which are, most commonly we see this with Creative Commons. This is the big copyleft institution that we think of, where they have a series of licenses that you can select and apply to your work, which basically says, hey, I'm going to let everyone in the world use my work, but you have to follow a couple rules. One, I think all of the Creative Commons licenses you have to attribute. So you have to at least give me credit and acknowledge me as the original creator of the work. And then there are other flavors of Creative Commons licenses, like some, you can use my work, but you can't make derivatives, you can't adapt it. You can use my work, but you can only use it for non-commercial purposes. So you have to distribute it for free. You can use my work, but you can only sub-license it as well, but you can only sub-license it with the same or a more expansive license. You can't get more restrictive. That's kind of copyleft in a nutshell, in a super nutshell. And it's this idea of using copyright protection to try and basically expand access to creative works and creative expression.
And I would add that even in the context of open licensing of copyleft Creative Commons, even derivative works are often acceptable and encouraged, but there will be a provision that says you cannot maintain exclusive ownership of it. In other words, and if any derivative work you make also has to be available to others to make additional derivative works of your underlying work. So you have to share in the Creative Commons concept. I think it's a very healthy mechanism that's not utilized enough.
Yeah. And a lot of this comes from copyright lasting an extremely long time. So, you know, we can all talk about the history of copyright. What you need to know now is duration of copyright lasts life of the author plus 70 years. If you have 2 or more authors, life of the last surviving author plus 70 years. And then you have this category, anonymous works, pseudonymous works, works made for hire. The copyright term lasts the earlier of either 95 years from publication, meaning when copies were made available to the public for, you know, our use and enjoyment, or 120 years from creation. Why do I have Mickey Mouse and Sonny and Cher here? Disney is why we have this. Disney was freaking out in the 90s. Steamboat Willie was going to lose copyright. Its copyright was going to expire, I think, in 2004. And Disney lobbied super hard to Congressman Sonny Bono. And Sonny Bono authored a bill that extended copyright for another 20 years and kind of changed the regime of how we calculate copyright duration. So we call it, it's the Sonny Bono Copyright Term Extension Act. All of us attorneys who think we're so funny, we call it the Mickey Mouse Protection Act. But it basically, you know, the crux of it was it gave Disney kind of 20 more years to protect Steamboat Willie before it went into the public domain. Because once the copyright in your work expires, it goes into the public domain, meaning any of us can use the work without restriction. We don't need permission. We don't need a license. We can make copies, sell copies, derive it, and do what we want with it. But
here again, though, there's a crossover between copyright and trademarks.
Yes.
Even if the Disney cartoons go into the public domain, certain images that the Walt Disney Corporation owns will still be protected by trademark law, and trademark law, as long as you're using a trademark in commerce, never expire. So they do end runs, not just in films with Disney, but in theater. The George Gershwin Foundation is famous for this. A few years ago, they remounted a production of George and Ira Gershwin and DuBose Hayward's Porgy and Bess, great old-time American musical. And what they did was, because it was about to go into the public domain, they retitled it the Gershwin Brothers Porgy and Bess. They added one song that had been cut from the original production and then applied for a new copyright term for the entire thing. It's still being disputed about whether that's going to be allowed.
Interesting. Yeah, so public domain, it means it has a technical definition that means that the copyright in the work has expired. But yeah, as Bruce said, it doesn't mean that all intellectual property rights associated with that work have expired, and that, you know, it doesn't necessarily mean that you're completely free and clear if the work that is in the public domain still has some other protectable intellectual property components to it, like a trademark, which can last forever. It doesn't necessarily mean you're totally free and clear. Like, you know, if you're using the name Mickey Mouse in, you know, your adaptation of Steamboat Willie or whatever, it's like, you better believe that Disney is going to come down hard on you and say, hey, we have 1 million trademarks in the name Mickey Mouse and you're violating our trademark, even though, you know, you're lawfully using Steamboat Willie, which references Mickey Mouse. Like, you're still using this element. You can't use that. You got to use a different name.
Another example, which I happen to love for personal reasons, is the Grimm brothers' story of Snow White and the Seven Dwarfs. Clearly public domain. It was written in the 19th century. The Grimm brothers have been dead for a long time. Plus, they were never in the U.S. to begin with. Schools today who put on a production of the story of Snow White and the Seven Dwarfs, totally free to do so. However, They are not free to use the names Doc and Sneezy and Sleepy and Grumpy because those are protected trademarks by, wait for it, the Walt Disney Corporation.
Mhm. Yeah, and Disney has probably the most elaborate and sophisticated understanding of copyright law, copyright, fair use, public domain than anyone else. Like, I mean, they built their whole animation empire on Grimm's fairy tales. And you know, when you think of Cinderella, do you think of the Grimm's brothers version, or do you think of, you know, the 50s version? So let's talk really quickly about registration. And this came up in a question earlier. So first, to answer a question here, you know, about kind of estates and things like that. Yeah, Patricia, your question, can I leave in my will copyright of a painting to an entity that doesn't necessarily own the painting? Yes, you can, because the ownership of the copyright and the ownership of the physical work are distinct. So, you know, think of it again like a book author. Like, you can transfer the copyright in your book to another company that doesn't necessarily own a copy of the physical book, but that doesn't necessarily change, you know, the ownership of the physical copies by all the people that might have physical copies of that book.
And here we get into the Visual Artists' Rights Act as well, Patricia, because it might be a subject to particular restrictions of what can be done, even by the owner of the painting. That can get involved with that, but we really don't have time to get into the details about that one.
Yeah. So someone asked earlier about, you know, can you talk a bit about copyright for photographers? How does it work? Do I need to copyright all of our photos individually, or just file one that will protect all of our images? It's funny because Bruce and I were talking about this yesterday. So first of all, copyright registration. Why do I do it? So copyright registration is basically recording your ownership, your copyright interest with the United States Copyright Office, an office of the Library of Congress, the United States National Library. The idea is basically you fill out an application, you send in a depository copy to our National Library. In exchange, they will issue a certificate saying, yes, we recognize you as the owner of this work, as the copyright owner of this work. That's what it essentially amounts to in theory. The idea of a copyright is, again, it creates a public record of your ownership. And really, for us attorneys, you need to have a copyright registration before you can actually enforce your copyright in an infringement action. You have these 6 rights. The real power of copyright is how you are able to enforce those 6 rights and how to control them. And chiefly, you control it by enforcing your copyright against people who are infringing, by filing, you know, hiring people like Bruce Yen and I to sue people for unauthorized use of your work. So the process is, it's simplified now. It's online for the most part, and it's comparatively affordable compared to other types of intellectual property protections like patent and trademark, but it still can be, you know, if you're a photographer that has thousands of photographs, wow, you know, $45 to $65 per photograph is not a drop in a bucket. There is what is called group registration of unpublished works. And these are for you to batch register for most artistic disciplines and types of works, up to 10 works. They have to be the same type of work. They have to be the same medium, the same kind of, you know, you can't combine like visual arts with music, but you can batch 10 of the same types of work together in one registration under one fee, as long as the works have not yet been published, meaning, again, copies haven't been disseminated to the public for us to consume and enjoy. There is an exception for photographers. Photographers get up to 750. Reason the Copyright Office cracked down on this like literally 2 or 3 years ago. It used to be put as many as you want in a registration, and someone at the Copyright Office decided, wow, this is untenable. We're getting copyright registrations, group registrations that have thousands of works in them. We can't possibly examine them. Let's cut it down to 10. Understanding photographers are, it's you know, they're always going to be having large collections of photos that they want to protect at one time. We'll make this carve out for them. You get up to 750 under one registration. The flip side is that copyright registration also entitles you in litigation. If you win a copyright infringement suit, it entitles you to what are called statutory damages, a range of damages, money damages set by the copyright law. I think between, what is it, like $750 and like 30,000?
For willful infringement, it can go up that high, it can go even higher, yeah.
Yeah, so, but that is, you know, if you have all of these registrations or all these works under one registration, that entitles you to kind of one bite at the statutory damages fees. So, you know, if you have 750 photographs and someone's infringed 100 of them, you're entitled to damages for that one registration. So
Let me also add, Luke, a couple things.
Yeah.
First, on the photography, I began my career when I was an undergraduate back in the early 70s as a still photographer. In those days, it was film. I would go out on an assignment and I would shoot 30 rolls of film on the floor of the New York Stock Exchange. That's 1,000 and some odd pictures. I mean, I could not afford to file 1,000 or so copyright applications. The 750 limit, the new law that Luke was talking about, which is a couple of years old now, not only limits it at 750, but it also establishes that they had to have been done at the same location or in the same assignment. So I can't take 750 photographs at random from my travels throughout Africa or Europe or the Middle East or South America and lump them together in a single copyright registration to save money. It has to have been done at the same assignment, more or less, or the same theme. The second thing, and this relates to what Luke just talked about, there's a concept in trademark law, which I hope we have time to discuss a little bit, called fair use, which is a defense to a claim of infringement. One of the prongs, one of the things that courts will look at is how much of a registered copyright, how much of a copyright proportionally was taken illegally, was infringed. If you own a copyright registration for a single photograph and someone illegally copies your photograph, they have taken 100% of your copyright registration. If it's one of 700 photographs, they've taken 1/700th of that. And so on a fair use analysis, the proportion would be very, very low. And a court might say, you know what, that's okay to use, that's not really infringement. Just throwing it out there. There are pros and cons to the group registration. One of the cons is that you might lose on a subsequent infringement claim. Yeah.
My general kind of rule of thumb and suggestion is, one, register your work. You know, if you expect to have a lot of eyeballs on your work and to, you know, either commercialize it or show it, exhibit it, and you're going to have a lot of people who are able to see it, then I recommend, you know, register it. And then also think about, you know, you do have to exercise some of your own judgment as to, you know, do I want to do a group registration, or, you know, do I want to, you know, these 10 photographs in this collection are really like, they're each their own kind of magnum opus. I think I want to invest in the $650 to separately register all of them.
And folks, I would strongly urge you, if you're going to register it, to do it fairly soon after you create your work, because if you do it within 3 months of the creation, or 5 months of creation, 3 months of publication, I can't remember the exact numbers, then you could be entitled not just to the statutory damages that Luke spoke about, you could be entitled to get attorney's fees as well, and they can be significant.
Yeah. So Sarah asked, for visual artists, does unpublished mean that artwork has not been shown anywhere? No, it really means that you haven't made copies available to the public for our personal consumption. And it's a little bit, I think it's a little bit trickier now with like digital distribution and stuff like that, and kind of digital portfolios. Like, there is some intentionality behind it. Like, if you're sharing your work on your online portfolio, you know, anyone can right click and download it. Is your intent for it to be accessible and downloadable and acquirable by everyone? Or is your intent really to exhibit your work? I think it's easier when you think like, oh, I'm doing a gallery show and my work is going to be exhibited at a museum. No, that's not what we consider publication. If the gift shop had prints of it and postcards and stuff like that, well, now we're getting to publication. So there is a distinction. It is kind of it is kind of a fine line. So we have 10 minutes left. So I want to, let's talk about infringement, but then let's get to fair use, because that's kind of the fun part. So copyright infringement. Anyone who exploits any of those 6 exclusive rights, make copies, make derivatives, distribute copies, public performance, public display, public performance of sound recordings. Anyone who exploits those rights without the copyright owner's permission is an infringer. And that also includes exceeding the scope of a copyright license. I've granted Yen a license to distribute my book for 3 years, and she distributes it in year 4. That is a violation of the copyright license. And that is an breach of contract and an infringement of my copyright. How do we prove that someone has infringed copyright? 2 pieces. I own a valid copyright. I, as the plaintiff, own a valid copyright, and the defendant copied my work. It used to be that we'd have this caveat that it's really hard to prove actual copying. So in most instances, we prove copyright infringement. We prove copying by circumstantial evidence that the defendant had access to the work. It was something that was distributed, or it was, a song that was published and downloadable, or that kind of thing. And the infringing work is substantially similar to that of the original. But that's still applicable, and that's still part of the standard for today. But I also think nowadays, so much copyright infringement happens digitally. Sometimes wholesale copying, sometimes, cutting and snipping pieces of existing works, that it's somewhat easier. It's kind of come full circle. It's somewhat easy to prove in some instances actual copying if it's, oh, they've just copied my photograph. They've right-clicked and saved, or command-clicked and saved, or whatever. But when you're dealing with works that are not necessarily exact duplicates, but are very close to an existing source material, that's when we get into this analysis of, did I have access to the source material, and are the 2 pieces substantially similar? And it is entirely possible for 2 people to independently create virtually identical works. It actually does happen. The example I think of is, let's say Bruce Yen and I are in a studio drawing class. We're all positioned more or less next to each other, all of our easels. We're looking at the same model from more or less the same perspective. We're all trained in the same artistic discipline. We're all trained in the same, school of visual arts. And when we do our drawings, oh, look, they are virtually identical. Is that infringement? No, we are simply independent creators that all had the same perspective. So that does happen. It
happens in the music industry all the time. It goes beyond. George Harrison of the Beatles was accused of infringing when he wrote "Hello Sunshine," I think was the song, or "Good Day Sunshine." Someone else showed, I've got the sheet music for something that I wrote. He was not able to establish that George Harrison had ever had access to it. So George Harrison was deemed to have independently created the work. It comes up. John asked a question about idea for a film or a script. No, you cannot protect an idea. You can only protect the work that's been fixed in a tangible medium. But in the film industry, it is very, very common for 2 people, 2 individuals, 2 entities to come up with similar ideas. And number one claims, oh, it was stolen, and the court will look at it, because we all want courts to make artistic decisions, of course. I'm saying that with my tongue firmly ensconced in cheek. But people come up with the same ideas all the time. It's a very high threshold. It doesn't mean it doesn't sometimes succeed. The film Coming to America, starring, I'm drawing a blank on his name, but Art Buchwald, a New York Post columnist, claims that he wrote a script for it and submitted it to a studio. And sure enough, he was able to prove the case and won millions of dollars in damages. Eddie Murray was the actor in that one.
Yeah, Eddie Murphy, and I can never remember the other star's name.
I saw the film, so I don't know.
And they just did a sequel too. So, and one thing is, so submitting works in progress for registering is kind of, I think in general, the Copyright Office says it really needs to be a finished work. I don't think that necessarily means you can't submit drafts, but you can't submit to them like a unfinished piece and seek registration for it. The idea really is we want it to be a finished work, even if it is an initial draft, not kind of the final version.
And not only that, but in the film industry particularly, where I have some experience, a studio is not going to read anything that you send them. They might read it if an agent submits it, but they will not read anything you send them unless you sign a document basically saying, I will not complain if you can show that you've had the same idea in your files, and therefore you're not infringing on my copyright, even if it's a finished script in that case.
Yeah. Yeah, that's super common, and really they want to avoid this issue. They, the film producers, the film publishers, they're like, I don't want to get sued left and right by everyone who thinks they've come up with like, whichever movie. I don't want 10 people coming in saying, I came up with Citizen Kane. Like, no, if you send us, we're not going to accept unsolicited things. You have to formally, go through an agent or go through an intermediary. You have to include this type of, you have to sign this paperwork and this contract that's releasing us from any liabilities for these things. Yeah, because this happens all the time. And I see this a lot where I have artists say, I came up with this movie. And I was like, I'm not sure you did. So in the last 3 minutes, I want to talk about fair use because it's a big issue, and obviously it's even bigger today. So fair use is a defense against the claim of copyright infringement. It is an affirmative defense, which means I admit that I used your copyright protectable expression without your permission. However, my use, I think, is justified by some type of public interest, some type of public benefit or public policy, research, education, scholarship, commentary, critique, parody, that kind of thing. There are certain public benefits and goals that we think outweigh a individual's or copyright owner's limited monopoly to control their work. Kind of classic example is if I'm a book reviewer, I might need to actually excerpt a part of your story in order to review it and to comment and critique on it. Or, any type of like critic, really. It's like I need to use the source material to criticize it. But there are other types of fair uses, and where it gets really difficult is in something like the Andy Warhol and Lynn Goldsmith case, where we have a creative expression, not necessarily commenting or critiquing the source material, but this question of, have I created something new? Is my work transformative of the original such that I've created a brand new art creative expression that doesn't really reflect the author's original intent and the author's original message. If I've now taken the source material and said something new with it and created a whole new work of art, then I should also be excused from, or I should also be considered not infringing against the source material. And this is the issue that we're dealing with in Warhol versus Goldsmith. Eric, are you here to give us the cane to play us?
Yes, I want to just say yes. Thank you for Luke and Bruce and Yen for your time today and all this great information. I'm just like, my mind is blowing at this point on how we can help all artists with all this great work. We're going to push this out all around, but in that we have a minute, you guys each want to give a closing thought and wrap this, tie it up with a bow, because it's been a pretty exciting hour and a half. We so appreciate your help.
It did take a long time. It flew by very quickly.
Yeah, it did.
Thank you. I will just throw my final comment to the people who are still with us listening. Protect your own work, even if you don't register the copyright. Do searches on Google or another search engine. Do a reverse image search for your photographs or painting. Make sure it's not out there without your knowledge. And if it is out there without your knowledge, take steps to stop it.
Yeah. And the thing I would say is, it's difficult to keep track of, especially online, where your work goes. Kind of once you've put it out there, you can't really control it anymore. The thing that I usually recommend to people is whatever platform you're using to share your art. If you are creative and you're on Instagram, you're a video maker and you're putting stuff on YouTube, or you're a musician and it's on Spotify, Bandcamp, SoundCloud. All of those sites have to have what's called copyright notice and takedown system. Basically, they have to give you some type of method for you to enforce your copyright and for you to claim and identify people who are infringing your work. Know what those policies and procedures are for whatever your platform of choice is. Instagram, Facebook, YouTube. Understand that notice and takedown procedure. It will save you a lot of headache in the future. Yen, do you got any last remarks?
Yeah, an hour and a half of awesomeness. Thank you so much, Luke and Bruce. Of course, if after this presentation you still have questions, because as artists, we have our individual issues, please reach out to Luke and myself. We're more than happy to either counsel you or point you in the right direction.
Thank you. And thank you, Tamara, and thank you, Eric, for hosting us.
Yeah,
Absolutely.
Just real quick too, on this slide, Yen's email is yen@artsandbusinesscouncil.org. So
Not to worry, because Luke will forward them to me anyway.
Yeah, she'll get them one way or another.
So you'll get, I'll get them anyway. So
that's okay. It was just, I could see
Thank
Luke just
you.
really wants to take in, all of the inquiries. No,
Right.
but
And then also don't forget to look at the chat, because we've sent Tamara's email address there as well, and a portal for all the other great activities on COA's website.
And please put my email address in there as well, Eric or Tamara, either personal b.jacoby@northeastern.edu or ipclinic@northeastern.edu. If anyone out there has a connection to Northeastern or lives or works in Massachusetts, we do provide legal services.
And
Okay,
also
I
just
will
to
do
give a quick shout out, Bruce happens to be a Connecticut resident, a Connecticut artist, and a past recipient of our Artist Fellowship program. So, we really are hearing from artist voices here, because again, Luke and Yen are both trained artists first and foremost before venturing into the legal realm. So we have individuals here who are well-versed in these topics for artists.
Excellent. Well, thank you all again so very much. And Bruce, just to your comment of, did we lose people? We didn't lose people. We literally had the same number, one drop, but I'll be honest, that was me on my iPad. I always have two computers running at the same time. So you didn't lose anybody. So it was a great, you got everybody trained. So thank you very much. All right, you all have a great, excellent rest of the day, and we'll see you soon.